where council authorized us to engage a firm, Denton, Navarro, Rocha, Bernal, Hyde, and Zeck, namely Mr. Charlie Zeck. Mr. Charles Zeck, to perform an independent review of the Home Rule Charter. And so that was authorized. I think Michael Ross did most of the correspondence with Mr. Zeck. Following that, he got started on his work. On the 16th of December, the Charter Commission had met again, and they actually completed their work and approved the Home Rule Charter document that each of you has been provided. We'd asked that Mr. Zeck would complete his work by the 29th of December, anticipating the discussion of the items here today to give you ample time to review that. He did complete that. Actually, on the 28th, he had a preliminary version of it. Grady, CJ, Michael Ross, myself, we had a conference call with Mr. Zeck to review his findings because, you know, he wasn't apprised to all of the background work that the commission had done, and Grady was able to actually clear up a couple of questions. He revised his findings, and you know, we got a very positive response, I believe, from Mr. Zeck. So we're here tonight to review those report that was provided. Grady went through, based on his knowledge and experience of the process, provided some explanations to the items. Several things mentioned were previously discussed and decided upon by the Charter Commission. I think, you know, subsequent to our meeting tonight, the council will have in their hands to call an election, which Grady's providing us preliminary ordinances and documents relative to that. Each one of the voters in the city of Fulshear will be mailed a copy of the Home Rule Charter, so they'll be delivered that in their hands personally, I guess through the mail, not personally. But. And then finally, we'll hold a series of public meetings, formally and informally, as we find opportunity to educate the public on the Home Rule Charter and what it contains for the city. We will have to get some advice from Grady on really what the exact position that the city can take. As politicians, we can take positions for and against particular ordinances or the Home Rule Charter in this instance, but the city has some limitations on truly advocating for or against the position. It's my understanding that we're in the business of providing the information, educating the public as a city, as an organization, and let them make their decision. So with that, I'll ask Grady if he would to review the report and maybe some of his explanations on those particular items, and then we'll open it up for the council to have any questions or comments that they might like to make on this subject.
Okay. I'm going to go off my letter that was in y'all's packet. It was in the Dropbox of December 30th. I cut and pasted Mr. Zeck's comments, which took out the charter provisions that he questioned. And then I had marked off Zeck's comments, which were his comments, and then I put in red my response so you can see the section talking about his comments and our response. That's how it flows. There were 4 legal issues that he referenced in his, I think, 6-page review. There were 6 form issues, 4 practical issues, and 4 policy issues that he commented on. I'll go through all of those. The first one, and you'll see on the first page of my letter, it was deleted. That was the issue of the 12-month residency period. He thought there was a concern in our conference call and follow-up call after that, we showed him how it was calculated. He didn't have a concern after that, so he just deleted it from the letter. Rather than go through and renumber all this, it was just easier to keep it matched, so I put delete there, so there isn't a, issue on residency on, for candidacy under the charter. Number 2, which was Article 3, Section 301 D and E, I call those the little yellow highlighters. I don't know if you see that on yours. Those are what I call cheat highlights, so I can just go right to it and tell you what it's about. This was a prohibition or ban if you are delinquent in paying your taxes or indebted to the city, you cannot, you're not qualified to be eligible for office. His concern was he thought that would be struck down as a violation of the 14th Amendment, and went through and quoted his cases. You will see that in my response that we brought this up to the Charter Commission. There is a split of authority between the courts across the nation. Whether taxes are being indebted, it can be a prohibition to your or can disqualify you from running for office. There is no binding legal authority in this district, in Fort Bend County, which is your state district court, or the 1st or 14th district courts of appeals, or the Texas Supreme Court. There is no binding authority that has answered this question clearly. There is some unpublished cases, and I know I'm getting into the fine hair of legal theory here, but unless you publish it, it doesn't bind you to follow it. There is a federal Fifth Circuit case that has commented on a case out of Longview, which was addressing a case out of the 6th Circuit and the 3rd Circuit, which I didn't go look up my federal circuits, but they're elsewhere. They could be California, Hawaii, or Ohio, wherever, but all commenting on this. So because there was a split in the authority, we made this disclosure to the Charter Commission. The Charter Commission was willing to make, to keep that in there. It was their call. Even though that could subject the charter to a judicial challenge, they thought it was worth it. As I said, warranted by a good faith argument for the extension, modification, or reversal of existing law. So they, as they say in sports, they called the ball. Or in baseball, they called the ball on it, and they wanted to keep that provision in there. I will say, which is not in the report, also included in your Dropbox is this spreadsheet called Fort Bend Home Rule Charters, 41 pages of sleep-inducing verbiage. You will see under number, it's on page.
Just right here. I'll pass it around. I printed it on bigger paper. My eyes aren't as good as reading.
I can get mine to print. On page 4, under numbers 12 and 13, we went through and we bracketed each Fulshear Charter section, and you can see that Rosenberg has this in their charter. Now, no other cities do, but again, this is what the Charter Commission decided to do. Now, I don't know if you want to ask me questions as I go through this, or you want me to deliver my whole sermon and then you can ask me questions or come forward. It's up to y'all.
Any questions at this point? All right.
Yeah, just on your rebuttal or reply here that you presented to us, you make a reference in each one of these things to either agendas and or minutes.
Correct.
Those are public information, right?
Correct. They are on the website,
Right.
the City of Fulshear's website. You can go check the page 9 of the December 8 minutes where this was discussed. So we went through. OCR is a wonderful thing. You can find it fast on it. So you can go through 5 where this was discussed, as it was discussed in July and August. Number 3, I want you to circle that when we're gonna come back to it. Because this is the at-large position that's caused the most discussion in the city. And Mr. Zek hits that 3 different times, and I want to just discuss that at one time. So we'll come back to number 3. Number 4, Article 8, Section 8.02, General Prohibitions. This is the anti-bribery prohibition. Mr. Zek commented that he thought this would be struck down, because it's inconsistent with the election code, that we couldn't, as a home rule charter, as a home rule city, could not add additional qualifications. And without reading everything he said, dropping down to my comments, the bribery issue was of particular concern to the Charter Commission. They discussed it on October 13th, December 8th. This was brought up to the Charter Commission. It was fully vetted by the Charter Commission. They were told that the charter could be subject to a judicial challenge. And I will say this about the Charter Commission. They were very dignified in their debates. They were very independent in their debates. They were very efficient in their debates. But there are some policy issues that they just bowed their back, and they said they wanted in the charter, and they understood the risk that the city may be involved with the charter, but they wanted an anti-bribery that says if you are convicted of bribery, you are banned from office in this city, period. We believe that this section is not, Election Code 141.003 can be harmonized with our section. And again, this was fully vetted by the Charter Commission, discussed, brought back up several times, and voted on to keep in the charter.
So Brady, one of the things that Mr. Zekin's opinion runs is that he's concerned about not giving deference to pardons, exonerations, things of that nature. Can you speak to us about the impact of an exoneration or a pardon, and how it, if it does or does not remove the disabilities of felony, and how that comports with the languages proposed by the Charter Commission?
Well, I'm going to defer a bit to Byron because he handled this section, but we specifically talked, I'll give you the big picture first. We specifically talked about pardons, or if you've paid your debt to society and you served your time. But they were so concerned about that effect on municipal operations, they still wanted to take that risk. Byron, if you want to fill that in.
And there was some debate with the commission about whether something like a pardon would entitle someone to a second chance if they're convicted of bribery, but the prevailing opinion that ultimately made its way into the charter was that the commission had faith in the judicial system, and so if someone were convicted, that would be enough for the commission to decide that that person should be ineligible to run for office. The only thing that I think might make someone eligible after that is if they go through the judicial proceeding of having their conviction expunged, and so that essentially nullifies the conviction, and that I think is the only thing that would allow someone to become eligible despite having been convicted.
This is state bribery only. The commission did not take up the issue on the federal level of bribery. So I guess you can cheat Congress, but you can't cheat the state.
Brady, I had a quick question.
Yes.
On the first two things that we've talked about, one of them was on the qualification about owing taxes to the city. This one is about a general prohibition for bribery. If this document is challenged, then those two things would be struck down. The rest of the charter would remain intact. And
there's a severability clause, yes. Short answer is.
So if this is challenged, they say, okay, well, if you're convicted of bribery, you can run for office. that's really out of our control.
Yeah. I guess you can have the briberies anonymous sue the city, or you can be a convicted briber and sue the city, but that's why we have courts, and, the commission wanted to take a stance, and they took a stance. They didn't take many stances, hard line stances, but this and taxes and indebted to the city were the three.
Okay.
Those were the,
Is that also addressed in the chart that's provided on the form of government? I just didn't see it. I didn't know it was 41.
robbery, I don't remember. I didn't look that one, I didn't go through and look that one up. I can later, but I haven't looked it up. Alright, those were the 4 legal issues. We need to come back to the at-large decision, but those were the 4 legal issues that he focused on. I'm next going to his part B.
Okay, let me make just one comment I failed to make before I turned it over to you, but, CJ McDaniel's the chair of the Charter Commission. He is here tonight just trying to observe and take in all of council's comments on the review document so that they can determine whether they need to meet again and have any further discussion. So, thank you for being here, CJ. Proceed.
McDaniels.
Yes.
Yeah, and this is not the 10 Commandments. I'm not Moses. After 2 years, this document can be amended. It can be amended by petition of the residents of Fulshear. It can be amended by establishing a charter review commission. In fact, Richmond has already got a charter review commission of the charter that they passed in 2013. Or the council can just directly propose amendments and it go to the voters to vote on those amendments. So this, over a very long process, it's more glacial than the 440, but it can be amended and fine-tuned as you see how it works. Okay, farm issues. I'm on, I didn't number my pages, I'm on B number 1. This is the appointments issue. He had a problem. He thought it, this section 3.01C was not clear enough as to the appointments. You can see what we said. And I chose the word, mostly charters have the word meet the following qualifications. I added maintain in there from personal experience. There is, the last 2 mayors of Piney Point Village moved out of the village, but because they didn't have a provision that says maintain, they could still be mayor. They live in Houston, of a different city. Don't think that's right. Charter Commission agreed. So it says must meet and maintain the following qualifications to be eligible for office. You can't appoint somebody that's not eligible for office. So if you, I just don't see what the problem was. We say meet and maintain means meet and maintain for appointments as well as elected officials. Pretty simple. Number 2, I want you to circle that one because that's the at-large position. We'll come back to that. Number 3, Mr. Zeck had a problem with the terminology we used, regular election. You can see he thought general election was more consistent with state law and the proposed charter. We were following local government code section 22.010B, which uses the phrase regular municipal elections. If you do a Google search of the Texas Secretary of State site, it's regular elections. I also went and pulled Mont Belvieu's charter that Mr. Zeck drew up, and that's the one I did the second opinion on. And I list out every place he uses the term regular election. The CF means cross-reference there. I also went back and added after the phone phone conversation, the sections where he used the term general election. So those terms are basically interchangeable. Richmond's charter, which both Mont Bellevue and Richmond's charter were, adopted in 2013, they use the term regular election. So we stand by the drafting on that. By the way, this chart that I'm referring to, it's got Fulshear, Cady, Missouri City, Richmond, Rosenberg, Sugar Land, and Stafford in there. Those are the home rule cities in Fort Bend County. So that the analysis can be done, and compared that to what Fulshear is going through. We use Mont Bellevue, an out-of-county city, both as a control, so it's outside of Fort Bend County, you can see what else is there. I'm familiar with it since I represent it, and Mr. Zek, had drafted it, so those are however many cities that are, in that review.
And just to point out on that specific one, there was no case law cited for that particular instance, that there's a distinction between regular versus general. And the case law that you're aware of that has a that doesn't have a legal distinction.
All right, number 4. Again, this is the elected or appointed officials convicted bribery and permanently ineligible. He wanted to change any person as opposed to any elected or appointed official. If he is saying that it was confusing that you had to be convicted of bribery when you were holding office, as opposed to prior to that. The part we say is that 8.02 A through D, if you read that whole section, it addresses city officials appointed, elected, compensated, or not compensated for the general prohibition, and that includes any person. Now, I mean, a lot of this argument at this point is saying, well, if I say you have to have a Ford pickup to do this job, and he comes back and says, no, you have to have a Chevy pickup, is there a difference between the Ford and Chevy? Well, yes, Ford and Chevy owners will tell you that, but really it's a pickup that gets you there. So, this is just language selection of any person. Franchises, number 5, section 2.02. This is one I actually agree with Mr. Zek on, and we discussed it at the Charter Commission meeting. Mr. Zek did not have it at all in Mont Bellevue's charter. He thinks it's supported. I can't pronounce it. Superfluous. We discussed the fact that it was not in Mont Bellevue's charter. We also discussed the fact that Richmond's charter, drafted by Frank Garza out of San Antonio, went on for 3 pages about franchise. We compared the two. The Charter Commission stated they want at least some reference, so we compromised between 0 and 3 pages and came up with what we have. Doesn't hurt anything. It just says you've got franchise powers and you can grant franchises. As he stated in his phone conversation, the state is taking more and more of that away from the states, i.e. telephone, cable, electricity. So it's becoming less and less of an issue, but there is at least some in there that we can hang our hat on and say you've got a right to grant franchises. Okay, number 6. Again, this is a regular versus general election, and it was compensation and expenses. And we'll get back down to that in one of the practical issues later, but it's regular, general, it's the same word. That's all the form issues. Practical issues under number C. He said the 3.03 did not address residence requirements from single member districts. That's for a reason. There are no residency requirements for single-member districts. We discussed that the charter there is a residency requirement under state law, and there's a residency requirement in the charter to live in the city. But we didn't want the gamesmanship that I've seen, in saying, when did you really move into that district? Or, an argument or a lawsuit on whether they really lived in that district that amount of time. Well, you had a rent house there. Were you really staying there? Is that really your residence? Is that your homestead? I've handled one near, election issue between the mayor and an opponent at a different city. The opponent was saying he lived in the city, and he had a house in the city. Everybody knew he lived with his wife outside the city on the little horse ranch. And it really comes down to quote Elizabeth Taylor, Texas is a state of mind. And really your state of mind is the proof of where your residence is. Where do I intend that I live? You know, you may have a house in Houston, you may have a weekend house here. You can declare your residence here in Fulshear, if this is your weekend house, and only come here on the weekend. But that's your right to declare that as your residence. We didn't want that type of, the Charter Commission did not want that type of fight during elections. So there are no residency requirements for single member districts, just to live within the city. Vacancies. A little known section of the local government code says that if you miss 3 consecutive regular city council meetings, you can be kicked off council for being absent. Let me emphasize consecutive and regular, not special, not this workshop. It has to be your monthly regular meeting. It has to be 3 months in a row. So you can miss 2, make the 3rd, and it starts all over. He thought it was harsh. What we were doing was following that section 22.041B, which is just consistent with the local government code of what you're operating under now. The charter gives the city council permission, and it's working in other cities I represent. There's just a standard line item on the agenda that says approval of council person's absence. And it's not a consent agenda, but it's as close as you can get to a consent agenda. No one's turned down a council member for going on vacation or an operation or a death or whatever they have. So, it may be harsh, but it's no harsher than what you're operating under. Number 3, and we're getting towards the end. Number 3 is there was no specific process in the charter to handle violations. And we discussed this because Mr. Zecker drafted some very good procedures that were included in Mont Belvieu's charter. But the Charter Commission did not want to load up the charter with process. The Charter Commission wanted you, council, to pass by ordinance. And if the charter passes, there will be several implementing ordinances that you will have to pass. But they wanted those processes drawn up by you, not dictated to you by them. And they wanted it to be able to be tailored and amended by an ordinance, by you, not having to have a charter election every 2 years and a vote on whether to add, pulling something out there, a 10-day notice or something like that. So they're the Charter Commission is giving you that flexibility and responsibility for you to set up your procedures for your conduct under 8.02D. And you can see where I'll reference that in a minute. Number 4, circle that, and that's the last circle. That's again on the at-large positions, and we'll come back to those. All right, D, policy issues. Administrative officers, The city manager and the chief financial officer are the one, two offices designated as officers. Frankly, it's to me a much ado about nothing. You by ordinance can designate who the officers are. The local government code designates for you for a general law city who officers are. But if you're going to authorize, someone else to, the city secretary to sign something with the chief election official at Fort Bend County, you do that by ordinance. And you say she's authorized to sign, that gives her the authority to sign that document. Again, it's more flexibility. I think Sugar Land has, the council shall appoint the city attorney. Some of the older charters have this, council shall appoint an attorney for the office of city attorney. It doesn't make a difference. You're appointing an attorney as the city attorney. There's a body of case law that goes over what officers are in tort law and contract law. So, yeah, we designated two. We didn't think any more needed to be designated or have a whole class of officers for the city. Number two, the positions of chief of police, finance director, and city secretary require the approval of city council for appointment and removal. The purest form of city manager, form of government would be those positions would be appointed and terminated by the city manager, not by city council. The whole policy, philosophy of the city manager form of government is y'all five, or in the future y'all seven, are a policy board. You're like the board of directors, and you set the policy, and the city manager enforces that policy, and that presupposes personnel too. It blurs the line, and the Charter Commission was aware of this. It blurs the line to blur that authority, and you take the chance of city employees trying to curry favor with you to get hired or to not get fired. The Charter Commission discussed all of this and decided on this position. They didn't want an all-powerful mayor. They didn't want an all-powerful city manager. They're trying to divest as much power in a body, which is the city council, and not in the body to the voters. They could have easily said, none of these are council approval to terminate or hire. They didn't. They could have split the difference and said, well, all right, city council gets the approval to hire, but not the approval to fire. They didn't do that either. They did this as what they did. But it was their policy call, so they called it like that. Initiative, referendum, and recall. There is a provision in the charter that, two provisions. One provision prevents IRR, is what I call it, initiative, referendum, and recall. That exempts certain categories of laws like tax rates. You could never operate a city if your tax rate was under a constant threat of an initiative or referendum. It's already built into the tax code because you've got the rollback rate. You all know about the rollback rate. The other section is any laws existing on the books when the charter is adopted are not subject to IRR because they were passed before that charter was implemented. And that is in Mott Bellevue's charter as well as other charters. You can look in the spreadsheet and find it. All right, the last one, number 4, is basically it requires a charter amendment to increase council pay. At one of the two, meetings with the charter commission, or the first meeting with the charter commission, that was brought up to me, went back to the charter commission. The mayor had always received some compensation. The charter commission reconsidered the question of whether the council should get paid for some amount for their, civic duty that they were spending many millions up here on. The charter, it would cause a robust debate among the commission, but they agreed to it, but they wanted to make it difficult to get a raise, that if you wanted a raise, you had to go to the voters to get a raise. Basically what it means. So, it was drafted purposely that way, so that you had to go to the voters if you wanted a raise. They didn't consider it a waste of a charter election. Charter election every 2 years, no sooner than every 2 years, requires each amendment to be separated out, and that, I know in talking with Michael, Westview did that, and it was a council initiated raise issue that went to the voter and it was approved. So, even though you have it every 2 years, you can have as many issues in that election as you want. Baytown did a major review of a revision of their charter, and they had like 24 different amendments on one election ballot. So you just load it up and go for it. But they hadn't done it in a long time, so it was time. So as I take it,
how does that practically, in practicality, work? I mean, I'm assuming you don't say, oh, well, we need to fix this, let's have a charter election tomorrow. When you start probably documenting, okay, this maybe could be tweaked, this could be improved, and then after some period of time, you have some body of items that you would like to consider changing, and then you bring that to, has that been your experience, Michael?
Yes, sir. What happens, assuming you're the home rule city and your council manager form of government, is typically your manager is one of the first people to sit down with that charter commission if they're called and assembled by the council, or the city manager is bringing, and it's because councils turn over time. So the next time the charter amendment comes up for discussion may be in an orientation with the new council, that this is something that was mentioned by the previous council as it was important to them, but their term was up. If you all would like, it could be considered for placement on an upcoming May ballot, within the 2-year period. And so that's typically how it worked, and I, as the manager, would just give them those highlights, and if they were important to them, they could include them, or they could appoint a charter commission and have it reviewed first and then placed on the ballot, either one. And most of them were actually just put on the ballot by council. There were 2 charter commissions that were seated during my time at the other city. That also
done in conjunction with just a regular May or November.
they were done with the regular elections.
there are only 2 uniform election dates, May and November,
Right.
so it would be a May or November election, and you would,
And our charter, as proposed, just specifies it has to be done, I would assume in conjunction with the election code, which is 78 days after an order, whether it's an whatever form IRR comes down in.
correct. So
What does IRR stand for?
initiative, referendum, or recall. Initiative is the voters initiate something they wanted on there that council has not acted on. Referendum is where the council has done something the voters are not happy with, and they want a referendum. For instance, an initiative in Baytown, they were mad, the firemen got mad at the city council, so the union got an initiative petition going to require 3 firemen on each fire truck. Council was trying to cut it back to 2 firemen per fire truck. So now there's a charter provision that says you gotta have 3 firemen every time you roll a fire truck. And that's popular vote, and that was an initiative. They can, have council, after a certain amount of time, can come in and propose an amendment to remove that, but, good luck. Then the final one is recall, where a council person is recalled, from their position for whatever reason. And differing petition requirements, and the commission set that one higher than the initiative and the referendum. Are we ready to move on to at-large? Okay, at-large is called the biggest debate, as I said, during this whole process. At the very first meeting, it was debated and proposed to adopt or change from your current status as 5 at-large, without place, plurality voted members. And by that I mean, everybody votes on you now. You're without place, which is very unusual. Most cities have place 1, place 2, place 3, place 4, place 5. And so that means you run for place 5, and anybody that wants to run specifically against you just runs for place 5. And you know exactly who your opponent is, and vice versa. And it's a majority vote. Now, I mean, what you're currently operating under is a plurality, as you know, and it's the top vote getters on how many positions are open. I always wondered why there was an imbalance here, why the mayor and 3 ran in one cycle and 2 ran in the other cycle, as opposed to 3 and 3. Bill Archer informed me that no one signed up one year for a position, and they finally appointed somebody, and it got off because they didn't have it for that full term. So, to fix all that, to make it even, and on the debate under the Voting Rights Act and the 14th Amendment, 1 person, 1 vote, the commission proposed and adopted changing from 5 at-large to 5 districts, which you have to reside in the city, you have to reside in the district to run. There's no length of residency requirement. And that means you, means a majority vote, and you know who your opponent or opponents are. You're not running against the pack, you're running against, or they're running against you as an incumbent for a specific position. There was a great debate on whether it should be, or the number of single member districts, and whether there should be at-large positions. And there is, you can read it and watch it, and all this has been in the Charter Commission Dropbox from day 1. You can see the debate from Blodgett and Texas charters. And by the way, Zach's paper, if you read the abstract, concludes nothing's really changed since 1994 in Texas council composition. So for the last 21 years, 22 years, nothing's really changed on how it's, yes, you can, there are different ways mayors are elected and that type of thing, but it's switched from 5 at-large, no position, plurality vote, to 5 single-member districts, majority vote, and 2 at-large. The theory is at-large positions represent more of the city as a whole. The theory is that a member of that district is just going to keep those district voters happy and not necessarily lift the big picture. I don't know that I agree with that, but that's what the theory is. So they voted to have 5 single-member districts and 2 at-large, and increase the council to 7, with the mayor not voting except in the case of a tie. Then legislation that was argued December 7th. And there is a, I'm looking for my, here it is. We discussed this. This was a Houston Chronicle headline from August of 2015. It's the Voting Rights Act of at 50 faces new challenge, and it talks about Pasadena getting sued by the Justice Department. So it was brought up to frankly give the charter, or to give the, let me back up. The Charter Commission wanted to give the council maximum amount of flexibility because we're no longer under pre-clearance. Well, let me make a footnote there. The current Justice Department is trying to put Texas back under pre-clearance by a lawsuit out of San Antonio. But we're not under pre-clearance right now.
It's frustrating. Manager, pre-clearance, for those of us who are attorneys, what does that mean?
I'm sorry, I should have made
I'm
that
sorry,
clear.
I'm just not.
No.
I couldn't follow all the language.
Right. The Voting Rights Act requires the states that didn't have a percentage of voter turnout on a magic date back in the 60s, that they then, any changes they made in any voting districts or the way you vote had to be pre-cleared by the Justice Department, even if you moved a polling place. For water districts, for mud districts, I mean, it went down to went all the way down to the littlest thing. Some precinct voting places are in people's garage, and they've sold their houses, so, and the new owners, I don't, get out of my garage, I don't want you here, you know? They needed to move the precinct place, so they had to go to Washington to get permission to move the precinct out of somebody's garage. I mean, literally. All the southern states, because of Jim Crow laws and all that, were under the Voting Rights Act, and Alaska. Now you ask me why Alaska? Because it snowed during the election, and they had real low voter turnout, and it triggered that they were under that provision. Shelby County got tired of it and sued, and in 2012-ish, the Supreme Court, even though they had re-upped the Voting Rights Act, said Congress did not do a good enough job in justifying why the state should continue under Section 4. And Section 4 is pre-clearance. You're still under Section 2. The whole nation's under Section 2. And Section 2 says one person, one vote. Now you've got that under the 14th Amendment, but you also have the Voting Rights Act that are trying to correct past discriminatory practices. And they have allowed majority and minority districts. And the Evanwell case is a question of, do you represent just voters or do you represent residents? Hawaii could get away with just voters because of the military. Because you've got a ton of transient soldiers and sailors in Hawaii that you can divvy those up based on population, but it doesn't really count because they're shipping out all the time, and you want the permanent residents there. So they allowed voters in Hawaii, and it went all the way to the Supreme Court on that issue, as opposed to just residents. So this is what the Charter Commission was faced with. Now I'm trying to figure out a way to delicately put what I'm about to say, because I had to delicately put it to the Charter Commission. If I had a mirror here and I held it up to y'all, what you would see is 4 white women and 2 white men. And I don't mean any disrespect at all. I don't mean any disrespect to any minority community. But you have a sizable minority community that's politically active, that had representation on the council. No, I have not heard any prejudiced word in the time I've represented this city. I don't care. But what I was concerned about was some young buck in the Justice Department wanting to prove himself or herself. And let's look at the second fastest growing city in the state. And let's go down there and see what's going on why all of a sudden we had a former black mayor and 2 former black council people that are no longer on the council. Right, wrong, I don't deal with that, I deal in what is the practicality. So the practicality was to try to allow an at-large or 2 at-large positions so that everybody had a chance to run. The question was, do you make them true at-large? And at-large, I mean everybody in the city votes on it just like with the mayor. Or do you try to restrict it or make it districts? This is where I then consulted with 2 Baylor law professors that have been doing redistricting and voter rights act stuff when I was in law school in the early 80s. So I pulled Professor Morrison out of his campsite in New Mexico this summer, and he finally got a cell signal, and we talked several times since then. We talked about, do you draw super districts, where you just divide the city in 2. You have District A and District B. And how do you draw that line? You draw it 1093, and everybody above that is District A, and everybody below that is District B. Well, that's not really population-wise. Do you draw it diagonally and split the city in half that way? And the eastern half across Creek Ranch is one, and the western half, and Fulbrook and Bodark is another. Do you make it by, and they came up with this, I didn't, a geographical restriction, not a district? And to say can't be from the same master planned community. People exercise their constitutional right to object to that, and that's all fine and good. But the point of the exercise was to give you flexibility if the charter is passed, and if it could be any individual, it could be somebody in the Justice Department, it could be the NAACP, it could be the Mexican American Defense League. Rosenberg was sued, and they have a consent decree in federal court on how they changed up their council. I don't know if that was the 80s or 90s whenever that happened, but they were under that for a good long while. Part of the Charter Commission tried to do, and we wrestled with this language through most of the process, was to give you tools to deal with the Justice Department to avoid a lawsuit, to avoid a consent decree, to where it gave you the option in the future to draw a district if you so desire, or to make other restrictions, whether it be master plan community, or whether it be some other thought process. But in the future, as I have said, I am not drawing those districts. Bring in the experts. The professors goes, oh, you know, we can pull the census data. No, you can't, because the Census Bureau had it all wrong in the last census. So that's not any good. You're going to have to build the data yourself. Well, we can look at it by precinct. No, that won't work, because Fulshear has been, until this year, 1 precinct. You are now 2 precincts. And that's what he and I have got to work on the election ordinance sometime in the future. Just tell him to do, I'm coming. So this was the whole intent by that provision. It's a little unusual, but that's the reason for it. So that's the context of Mr. Zeck's comments, and I'll try to summarize them. His first one was, it doesn't say when you must adopt this. That's number 3 under legal. The next one under form, number 2, it doesn't say if it's coming from one of the single member districts. And number 4, under practical issues, you could redistrict somebody out, an unpopular incumbent, somebody out. You could redistrict an unpopular incumbent. So let's take it in reverse order. If you had 2 districts, or super districts, so we keep them straight, and unpopular incumbent was here, you could move that district line over and take him out. Well, guess what? You can do that with the single member districts. So the risk on an at-large position is not any different than for the single member districts. Some cities, read Chicago, play those games in redistricting somebody out. It's part of the risk you take in single member districts. So even though you could redistrict out an unpopular incumbent at large, you're still gonna have to act fairly, you're still gonna have to act legally. And if you're under the, spotlight of the Justice Department, they're gonna grade your report card. So that's, number 4 under practical issues. It's there, yes, there's not really anything you can do about it, you're gonna face it, but the Charter Commission trusted the council to act fairly, equitably, and legally in that process. All right, going backwards to number 2 under form issues. The intent, and Charlie did not have the benefit of the minutes, but the intent was that these would be super districts, they would not be coming out of single member districts. So he was concerned about the wording, that districts is confusing between super districts or single member districts. Okay, we can add the word super district, if that's, will clear up the confusion. Or you can amend it in 2 years and put super districts. You may not pull the trigger. You may allow, currently as it's written now, the 2 at large are truly pure, I can't say that fast, 2 truly pure districts at large. No restrictions at all, they can come from any place. So, super districts, not super districts, okay. And then lastly, it says, number 3, which is the first one, it doesn't prescribe when the ordinance must be adopted, imposing those restrictions. And you can see how all that red on the paper there, that this first was discussed July 28th and went all the way through December 8th. The commission really did not want to try to dictate to council or tie your hands in the future on what any type of restrictions or qualifications will require. Like I said, their deal is we want the federal Constitution with 24 amendments, not the Texas Constitution, literally with 491 amendments. If the charter gives you an option to do something, you have to do it legally, and you have to do it pursuant to the law. So his question was when, and Tiana, we're on 3 under legal. Okay, sorry. And his concern was, well, if you call an election, for instance, February 19th, and all of a sudden you come in there and pull the trigger, well, you're gonna have to live in this district, you're gonna have to do this, you're gonna have to do that. That's after declaring for an election. That subjects the city to a lawsuit. And the commission, believes, the council will act in a legal and proper manner in making these qualifications in time enough before you call an election. Otherwise, you're gonna subject the city to a lawsuit.
Well, wouldn't that apply to any amendment? Even if you call an election and say we have a referendum, the time would be when it's considered, and it couldn't be enacted until it fully goes through the process, so time is always, I mean, if you call an election, you're bound by what the rules are at the date you call the election, and anything that changes would apply to the next one. But that would be for any change, right?
Correct.
Okay.
But
He just
so-
wanted it in the charter to say before the qualifications. I'm saying we have to obey the law anyway.
Right.
I mean, we always have to obey the law.
I know this is not what he said in here, but at least not what I've read, but I don't know. Are you gonna be guiding us through the process going forward? And I know this is not exactly the subject of this, but I mean, as I was reading the, you know, the specifics and the timelines and everything, are you gonna be leading us process-wise to the next stage?
Yes, I did that in Mont Bellevue. When the charter commission finished there, he was done. So I did my second opinion on it. They did some of the changes, they didn't do some of the changes. Then it came up to council to call that election, and we went through the whole process, the mail outs, the notice of elections, the Q&A to non-electioneer, because you still have the election code you have to follow, and then the council procedures and other implementing requirements. Yes, Dan, short answer is yes.
Because I think the education is always important, that is the key to, we probably should have gone through this process at the very early beginning to understand how home charter, you know, is gonna evolve, so.
Sure.
We are, so thank you.
Yeah, the process now is, I'll get into processes, is pretty straightforward. The Charter Commission finished their work December 18th and proposed, or December 15th, whatever I put on the charter, December 15th, and made that proposal. Chapter 9 of the local government code that says this is how you create and adopt a charter commission and create and adopt a charter. Says council must call an election at the next uniform election date. That date is February 19th is the last date to do it. That doesn't keep the charter commission from coming back and making, you know, if they wanna change regular to general, I don't care, I think it's the same word, but okay, if they wanna meet and do that, fine. But that doesn't reset the clock, it's still February 19th to do it. That then is, you've shown on the, timeline in your Dropbox, certain milestones have to be met. The city secretary has to mail a copy of the charter to every registered voter in the city. At the last election, I think the registered voters was 3,200 and something. I'm sure it's grown, so you're gonna have a massive mail out
But 35 now.
of 3,500 copies. Hopefully you can put it on two sides of the page and maybe do 4 pages per side, but, it's what the law requires.
May I address, Chairman?
Sure.
Mr.
You're
McDaniel,
on.
you had an opportunity to participate in a conference call with our city attorney, the mayor, both of our administrators, and Mr. Beck. And did you take all the information, the memorandum, the opinion, and disseminate this to your commission?
Yes, I sent it individually to each member with the comments, so that everyone would understand each of the items that he pointed out, both in terms of legal issues and form issues and so forth. I have responses from Bill Archer, Randy, Polly Royer, John Dowdall, maybe one other. Basically, and the consensus was that these are all things that we discussed, these are things that we understood going in, and we're happy with our work. If city council has things that they want us to evaluate, we'll be happy to meet again and evaluate.
I would urge y'all to look at this, because we really tried not to go too much off the trail. We did with bribery, we did with taxes and indebtedness.
Franchising.
And, well, okay, that's not much off, that's a step off the trail. But you can see how other cities, have done it. Some of the charters, Missouri City is the eldest charter in the county, and that's 1974. And then the shortest time span between two cities drafting the charter was 4 years. The largest time span was 14 years. Last time it was done is 2013, and then prior to that, it was 9 years prior to that time. So it's not done very often. But
Bellevue was 2013.
November is when they adopted it. Richmond adopted theirs in May of 2013.
Can I address franchise?
If the mayor will allow you.
Can I address franchises?
Oh, sure, go ahead.
CJ shared with us the frustration, literally, of losing a lot of control with franchise. And we understood that. However, none of us know what technology might suddenly come upon us going forward in the future. We just didn't wanna close our doors and not have the city have the right to have a franchise if some significant new technology that none of us even fathom would exist, and if suddenly somebody wants to get it into the city of Fulshear, we didn't wanna lose the revenue stream from that. So he said, let's put something in there that protects the city, but not 17 pages large. The city of Richmond had. So that was our thinking.
Any comments or questions?
Anybody have any comments on any other section of the charter that Mr. Zach didn't address? I've slept with this thing, and for 6 months I can probably quote it by
Yes, annexations. In my talking to constituents and my review, reading them, where's the annexations address? And, have we taken a look at that? Because I think that's one of the critical things that, you know, we're looking forward to is the ability to unilaterally annex without the petitioner coming to us. What's the
and-
timeframe? Is that covered in here or not? Is that gonna be part of the procedures?
Oh,
and
annexation?
process?
Oh, I thought you,
Annexations. It's
the
not
allergies,
annexation.
no, the allergies, I thought you said annotations, I'm going footnotes?
Annexation.
No, annexations are addressed in there.
That's section 2.3. Can you talk a little bit more about that?
Sure. Under general law, you know, if you have a three-way roll, a large general law city, well, let me back up. When y'all were a 500-member farm community, your three-way light bulb was about 50 watts, and that's not an insult, that's just how cities work. You are now 6,000 to 8,000 person general law city, you're at 100 watts. If you go home rule charter, you get to be 150 watts. You get more power. One power of that is you do not have the right to just go out and annex. General law cities do not. You have to have permission of the landowners. With home rule, you now have the power to unilaterally go out there and annex. Now, employee, landowner gets agitated over it, we're not taking your title to your property. All we're doing is adding a patina layer of city regulation over your land that you are now, required to meet building codes. So for instance, the city was approached by the Waller County RID number 1, Waller County Road Improvement District number 1, which is where Rooms to Go is, and they petitioned us to come into our ETJ, and we did a special purpose annexation, to get sales tax from there. We could not have gotten them unless they came to us first and asked to come into the city. If we were Katy, if we were Richmond, if we were Rosenberg, if we were Houston, we could have simply, so long as we follow the law and procedures involved, simply gone out there and annexed them and brought them in whether they wanted it or not. Now, that's a very simplified version because you've got bond issues and contiguous issues and all that. But it is that's probably the single most important power that a city has. Another, Councilwoman Messick, is last week, and it's public record so I can talk about it. Last week, the city of Meadows was sued by Texans for Justice. Texans for Justice is an organization in Denton, Texas, and North Texas representing sexual offenders. Meadows was sued over an ordinance I drew, over the registration and the number of feet you had to stay away from schools, parks, where sexual offenders can congregate. There is a Texas Attorney General opinion that says home rule cities have that power to regulate sexual offenders because the state has not preempted that. He also said that general law cities do not have that power to regulate and make sexual offenders stay a certain 1,000 feet away or whatever. So just like Fulshear is surrounded by Houston, by Katy, by Richmond, by Rosenberg, all home rule cities, they have a power to say sexual, I call them sexual predators, sexual offenders have to stay a certain amount of feet away. That has a tendency to try to herd those people into general law cities that don't have that power to regulate. Meadows' position when they adopted it in 2004, 2005, and I will admit I drafted it, and I told them, it's questionable. And they said our kids are as important to us as kids across the freeway in Stafford, in Houston, every place else. So now they've been challenged, and you don't think that the mayor and council are hopping mad that their ordinance could be, and they have an actual sexual offender trying to move into the city, and so we think it's a big setup, but it's on file in Richmond in the district courts down there. So with the power of a home rule city, you have that power to regulate that type of activity. Today, you don't. And so I think that's a very, very important aspect of the benefits of a home rule city. Your sign up there says 1977. This form of government was set up in 1977, and it's worked fine, and y'all have grown tremendously under it. This is, if the voter, and it's the voter's choice, if the voters approve it, it sets up the structure of government for the 21st century for y'all to manage what you need to manage.
Brady, if I could get you to clarify this real quick, because I don't want the council or the public, our ability to annex is predicated on an annexation plan that's adopted, and it's essentially a 3-year process. It's not like we will be able to go out and just start bringing property in. I just wanna make sure that that's.
Thank you, CJ, because when I read the section 2.03, this is what it reads: authority to annex and disannex, and it has A and B. And A says the city shall have the power to fix the boundaries of the city, to extend the boundaries of the city, and annex area adjacent to the city, and to exchange area with other cities. Great. B, any area of the city may be disannexed pursuant to any procedure allowed under state law whenever, in the opinion of the city council, there exists within the corporate limits of the city a territory not suitable or necessary for city purposes. One more sentence.
Yeah.
The city council may discontinue said territory as part of the city by ordinance after conducting a public hearing on the matter. So it's a really nice letter of the law, very factual, but as CJ said, I don't really see any years on when we can start annexing, so what I'd like to see is some guidance around that. It's probably not in the document itself,
Right.
but where can we find that?
Yeah.
Can I just say that predicating all that is on general powers, that we shall have the power of local self-government to the fullest extent permitted by law, and shall have all powers possible for a city to have under the Constitution and laws of the state of Texas as fully and completely as though they were specifically enumerated in this charter, with all implied powers necessary to carry into execution those powers, and those express and implied powers necessary to the government, interest, health, welfare, and good order of the city and its inhabitants. So would it incorporate the details of what Ms. Messick's asking, in addition to incorporating your specific example on, that you gave about regulating?
A home rule charter gives you all the power that the state has. So you're your own little state. Except for when the big state, Texas, says you can't have that power. Like sales tax, they're gonna get their 6 cents before you get your 2 cents. And you can't go above the 2 cents. To answer your specific question, typically charters don't reference the state law because state law, or reference a section to state law because state law is constantly changing. For the last, since I've been in Rotary, started it before then, started in the late 70s, they're codifying, they're putting everything in codes. And so what may be Vernon's annotated statutes, blah, 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 is now, Business and Commerce Code, section so-and-so. So that's why it's not in there. As far as annexation, did you know Alvin was a seaport? I didn't know Alvin was a seaport until I represented Missouri City and we tried to annex part of Sienna Plantation. And they had these great annexation wars. And Alvin annexed a 100-foot wide, 135-mile long loop in Brazoria County that touches San Luis Pass. So they are like Galveston. They did that in the 30s, the 30s. They did it because Hitchcock was a big threat. You see how big threat they are now. That's when the legislature stepped in with the annexation laws. And so there are certain constraints. Most cities, like Houston has an annex. I don't think Denise Parker annexed anything, or nothing controversial. And before her, Bill White didn't. Mayor Bob was the last one that annexed Keenwood, that caused a great annexation war in the legislature, which changed all the laws again. So everything the city does under a charter still has to comply with state law.
I think all of this information that you have shared with us tonight is very, very valuable to share in a town hall format, to educate our public, educate us a little bit more about this. And, I'm gonna go back to saying, I think this could have been done earlier. I don't want to cry over spilled milk, but educating us on the general provisions of the home charter, how, for example, I think authority to annex and disannex is very important for us going forward. So I'd like to know a little bit more about, not just from the home rule charter perspective, but the applied authority to annex and disannex after the charter is adopted or in the process of that.
I'll be glad to wax eloquently on that. There is a case, Granbury, or Crescent versus Granbury. There are 2 cases. I represented Crescent, and it was the great annexation of Laura Hood County. It's where I happen to grow up. And there is such a thing as a Court of Appeals injunction. So I can do that, but that's y'all's call if you wanna have something that doesn't, I mean, tick tock, the clock still ticks on that, responsibility to call an election. All this education, whenever y'all wanna have it, can be done, during the spring.
CJ, how much did we budget in our most recent budget for our public education aspect of the town hall
For the
meetings?
whole process, we included, I think, $25,000 in last year's.
So we have plenty of money to conduct town hall public hearing, or public meetings.
Yeah, we
to educate her.
do multiple
Great.
meetings.
Thanks. Cause I figured we budgeted for that.
I think we had 25 in last year's and 25 in this year's.
Okay.
So the total for the home rule charter process itself, do you remember off the top of your head what the total?
Well, we're right at 50 between the two.
How much?
Between the two fiscal years, right at 50, I believe.
That's just for the education part?
No, that's for the entire process.
Are we close to that?
We're bumping up against it, yes, ma'am.
Okay, so how much do we have in contingency? Cause we're paying
We've got $85,000.
85,000, 4,000 for the opinion we just got from Mr. Zeck.
Right,
is
we've got $85,000.
Okay.
In addition to that?
81 at least.
Maybe one, yeah. Well,
We gotta pay Mr. Zeck his 4,000 for his opinion.
Any questions about the charter provision?
Questions?
What did they have to say?
Any further comments or questions?
Well, I figure since this is a workshop and we're sending it back, I wanna make sure that we've got everything out that we need to have out, and so that we can timely call this. I mean, if we're working on drafting our ordinance for the election chart, Misty, I don't mean to put you under a time constraint, but I know we have 2 precincts, and I know that just happened January 1. But is that information pretty readily available from our county clerk?
I'm sure I can get it.
Okay. Alright, so I wanna make sure that we have all of our information, so we can start the education process, and if our commission needs to reconvene, then we need to.
All
figure it out.
132 pages of the agenda and minutes are on the city's website,
As is the proposed charter, right?
as is the,
Yeah, I think we've got to get the corrected version. Somebody told me that they fell back to the previous version, and
all that was
We'll
was
verify that.
we don't have a signed version?
We don't have a
Yeah,
sign.
but we have a final version.
and if y'all wanna put this up, I also included the survey that came out of Logic. That's a good, quick way to see.
Is that the one with the circles on
That's the
it?
one with the circles. That's a good, quick overview of what's in the charter. And also the timeline. I mean, none of this stuff is confidential. Put it all up on the website. It's all out there to educate the citizens.
Brady, I assume your document, that you sent to us to review, that's public document already.
I'm not sure what they,
Yeah, there was
this is
just
the
a-
old one.
Somebody had reported to me that it was the old one. I thought it was,
The last time I checked, I sent you that email and said, the most current one has December 15th at the very bottom. The only difference is, my numbering was off, that one of y'all pointed out to me. It was 7.1 instead of 7.01, and so I put the other digit in there on those. And, I had changed the one on, it said the city shall appoint the municipal judge. I changed that to the city shall appoint, the municipal judges. And if you ever wanna appoint more than one, you may, you have the power.
This doesn't have a date, but.
CJ just pulled up the one on the website. It doesn't have a date on the front, so we
But
will
it's not from
ensure
us.
that the approved and recommended document from the commission is the one that's available.
The one in your Dropbox is the most current one.
Correct.
That's
It does have the date.
yes.
Is there, so, I hate to belabor the point, but I just must, on the procedures and processes. So going forward, I understand from gonna have public meetings where you're gonna educate the public on the process, right? Not the process in the past, process going forward, the transition, the implementation, what happens next? So the public can just go and vote yes without any, confusion or questions. So I'd like to make sure that we're working on that as we integrate that into our process.
Sure.
Tell me, I think it's more for you, yeah.
Right, and maybe as we hold public meetings, as we, garner feedback, I know with, sensitive issues like we did with zoning, we actually, CJ put together a pretty good, frequently asked questions list that takes just the crux of the matter. They don't have to read the whole document, what is the annexation power of the city? And we can put some of those caveats in there to explain in layman's terms, so that it's clear what the document, says.
Richmond had a public hearing. They weren't required to have a public hearing, but their minutes reflect they had a public hearing. 4 people showed up, 1 person asked a question. It adjourned and they went on to.
Well, maybe it's a part of one of our sessions coming up in the spring, that we have just a public, in addition to town hall, when we meet in regular session, have that as part of the
Do that. And I will note that, in our conference call with Mr. Zeck, last week, he did make the comment that it was a well-written charter, so want to thank Grady and the commission and Byron I probably should thank Byron mostly, right, Grady?
Absolutely.
We're doing the heavy
But don't
lifting.
thank Tim.
Tim's
We're
agenda
still
is
in
big,
rush for it. He has better help.
but, and so that was very complimentary on his behalf, and so we appreciate the dedicated work that he's doing.
And Charlie said it was very hard for him, I'm sorry,
No, go ahead.
It was hard for him to try to review this with, the minutes, although they were online. His main concern was, did the charter commission vet this, and did they make an informed decision? And that's why I went through bit by bit and showed you the minutes by page where the commission did that, so.
And you discussed that with him as well, right?
Ma'am.
With Mr. Zach, you discussed that with Mr.
Yeah.
Zach as well?
That's why it was an hour and a half phone call.
Right.
The minutes on the website, right?
Yes, ma'am.
Minutes on the website.
All except for the last meeting, which I don't think had been approved by the, are they? I don't know. I know there's a date on the website.
Should come out.
And it's not a hot link, so. Did we get those yet?
No, 16th.
I don't know if we have the minutes up yet from the last meeting. Did Lynn send them out?
Yeah.
They're not.
They've been drafted, but not
Okay,
approved.
they've been drafted, they just haven't been approved by the charter commission. We can put them up and put draft on them, but till they approve them, I think. Don't wanna miss it.
Any further questions, comments?
I know there's a deadline for calling the election. Is there a target date that you had in mind? Is regular meeting in January, regular meeting, February, regular meeting would be too late?
I would like to shoot for the January regular meeting.
Ordinance is almost there.
And then if nothing else, before we adjourn, just if I could ask everyone, we had another issue we needed to discuss, and would y'all be available on January the 12th, which is a week from today? Well, the idea would be to have the other meeting at 5 PM, this meeting at 5 PM, which would allow you to go to your, tree ordinance committee meeting at 6:30.
I just wanted to ask Mr. Ross.
Thank you. Everybody's good?